Good afternoon. Attorney Protective would like to welcome you to today's webinar, Socially Responsible: How to Ethically Use Social Media in Your Practice. Please reference your materials for information about today's speakers, Alicia Sulak and Josh Byrne. With that, I would like to introduce your first speaker, Alicia.
Hello, everyone. Thank you for joining us. We're looking forward to talking to you today about these important issues regarding how to ethically use social media in your law practice. If we want to jump ahead, we are going to focus the presentation on kind of two main areas. One is reviewing recent developments in case law and disciplinary matters pertaining to the use of social media, and then how the rules of professional conduct impact our obligations as attorneys with respect to using social media. And we'll sort of wrap up with some tips for your practices and how to ethically and competently use social media in those practices. We can jump ahead. Great. Okay, so when we're looking at the types of cases we see involving social media issues, and this says malpractice case review, but really these issues arise both in the context of attorney malpractice and in the context of disciplinary matters. So we'll be talking through some examples in both of those areas as we walk through the various topics. You'll see sort of two themes of issues that arise in connection with social media usage. And the first is, I think, what you're probably expecting to hear us talk about today, and that is the improper usage of social media. And this pertains to the types of cases where you see an attorney publishing client confidential information or commenting on a pending case. And those are, kind of the big headlines that we see in connection with social media usage. When I was doing some research for this presentation, an article that I read said something to the effect of, social media does not create ethical problems. It just makes the unethical conduct more publicly known. And I think that's an important way to look at this. Your obligations as an attorney are the same, whether you're using social media or not. It's just that social media gives us a new avenue to potentially fail to comply with our duties owed to our clients and to third parties. The usage of social media impacts our duties with respect to client confidentiality, truthfulness to third parties, competence, diligence, conflicts of interest, lots of topics that are covered by the rules of professional conduct, and areas where we can find ourselves facing malpractice claims. The second theme is maybe one that you're not expecting to hear as much about, and that is the failure to competently use social media. We'll get into more details on this, but Model Rule of Professional Conduct 1.1 requires attorneys to competently use technology. Attorneys are obligated to understand technology and to use it when it can help your representation of your clients. This means that you need to know and advise your clients on their social media usage, and that you need to know how you can use social media in your practice to further your clients' interests. We will be talking about a number of sample cases, sample disciplinary matters as we go through, but I just wanted to highlight a couple of examples off the bat that cover these themes. Okay, and with respect to the improper social media usage, recently in Pennsylvania, an attorney was just suspended for a year and a day, which requires the attorney to petition for reinstatement due to improper usage of social media in connection with representing a client. The attorney represented a plaintiff in suing a cat food manufacturer after their cat passed away. The food had been voluntarily recalled for an issue cited by the manufacturer, and the attorney posted on various social media avenues characterizing the voluntary cat food recall as a cover-up, falsely stating that the manufacturer had used chlorine in connection with manufacturing the food, which was essentially baseless and found not to be true. And the disciplinary board recommended, and it was accepted, a 1 year and 1 day suspension because the attorney had basically completely disregarded the truth in connection with making these social media posts. And so this goes to that first theme of improper social media usage and the obligation of attorneys to make sure that posts that they are made are truthful. Then with respect to the failure to properly use social media, this goes back about 10 years, so I may date myself on my use of social media, but in a criminal matter pending in the Ninth Circuit, a criminal defendant was able to prove ineffective assistance of counsel when his attorney had failed to introduce as evidence an away message posted by posted by the victim. The defendant had been accused of committing lewd and lascivious acts upon his minor stepdaughter, and prior to the defendant's trial, the stepdaughter had posted an away message which retracted her accusations against the defendant. The defense counsel failed to introduce that away message as evidence, and ultimately it was found that the attorney had provided ineffective assistance of counsel for failing to use that evidence in defense of his client. So you can see that our obligations with respect to social media both pertain to our proper use of our own social media and our inquiries into our clients and other parties involved in our cases' social media, and we'll get into those aspects more thoroughly. One thing that I think Josh probably wants to jump in on is the effect of First Amendment rights on an attorney's use of social media. And we have a very recent discovery opinion in the Philadelphia Court of Common Pleas addressing those issues. Josh, you want to talk about the client inspector case?
Sure. We have a case here in Philadelphia which involves one of the larger, more prominent plaintiffs' firms and one of their former partners who has gone off on his own. And both parties have engaged in something of a social media war, particularly the younger attorney. And I saw on one of the previous slides that the case of Client Inspector v. Bosworth is noted there. That case is worth looking at because it deals with essentially both parts of what we are talking about today. To a large degree, it is dealing with the negative aspects of Mr. Bosworth's representations on TikTok that Client Inspector have asserted are both defamatory and in some cases are actually asserting or putting their clients in a potential danger position. They have suggested that a number of the posts have anti-Semitic overtones. The court has generally held that Mr. Bosworth's TikTok videos are allowable, but both sides have been cautioned. And Mr. Bosworth has had a little bit of trouble in other cases throughout the Commonwealth because of utilizing TikTok to talk about client cases. So here we have an ongoing dispute between two firms with respect to the use of social media and particularly with talking about your former partners. This sort of, again, goes to the idea that none of these things are really new, and none of these things really have anything specifically to do with social media. You will get in trouble for bad-mouthing another person, another professional, on social media in the same ways that you would if you put it in a newspaper article back in the old days when we used to get our paper with 25 cents from a box on the street. If everyone will hold on just a second, I believe Alicia got kicked out and she is calling back on now. So our apologies for the technical difficulties here. As you can see, technology bedevils us all. One of the things that has bedeviled attorneys for a number of years now is the fact that the rule of professional conduct in terms of competency has been amended to include competency of the benefits and risks associated with technology. One of the areas that I think we don't think about is how that affects discovery. And it is my opinion at this point that any one who is representing a defendant in a personal injury action who does not identify, who does not look for social media of the plaintiff is perhaps violating that rule. It is not uncommon these days to have a plaintiff who has asserted that they are completely disabled to be making Facebook posts that include dancing at Renaissance fairs and that sort of thing, which is always useful. To be fair, in disciplinary actions, to my knowledge, there are none, certainly in Pennsylvania, but none from other places that I am aware of, where a violation of Rule 1.1 with respect to technology has been the sole basis for a disciplinary action. However, there are many instances where folks who represent counsel in disciplinary cases think that this is likely to occur. One of the most obvious of these is if you do not have appropriate protections for client data. A data breach which cannot be explained is something where you may well have a possibility of somebody asserting that there was a violation of Rule 1.1. Alicia, I think you were about to go on to a different subject before you got kicked off, and she's out again. If we think about Rule 1.1 and Rule 1.6, the duty of confidentiality and the duty of competency have not fundamentally changed. We want to keep our clients' information confidential in the same ways that we would under paper. The difficulty is that there is more opportunity to inadvertently disclose attorney-client confidential information. Alicia, I think you're back on and ready to resume talking.
I am, yeah. Sorry about that. A little technical difficulties on my end, largely because my speaker and mute buttons are right next to each other. So anyway, okay. So we can advance to the next slide. And again, this is just sort of an overview of some of the additional rules of professional conduct applicable to social media usage, and we will get into some of these in more detail with some examples later in the presentation. Rule 4.2 of the model rules covers a lawyer's obligations with respect to communicating with represented parties. And again, as Josh said, the obligations of attorneys under the rules of professional conduct do not change when social media enters the picture. But it's important to remember that just like you can't call a represented party and speak to them about a matter in which they are represented, you can't communicate with them via social media. So that includes sending messages, commenting on social media posts, responding to comments that they have made to your social media posts. It is easier in this less formal setting of social media to inadvertently make a mistake like that. So it's just important for attorneys to remain diligent in understanding their obligations and not communicating with represented parties in any way, including via social media. Next is maintaining client confidentiality, and I think Josh covered that in the last slide, and we'll talk more about that with some examples as we go through the presentation. And with respect to researching potential jurors online, there are some ethical opinions regarding the ability to do so. Of course, you cannot communicate with potential jurors in connection with researching them or gaining information about them. without violating the rules of professional conduct. We can jump ahead. Okay, and I think I'm going to take this and the next slide in connection with one discussion on using social media for discovery and the advice that you can. And there's two areas where social media impacts discovery. One is your investigation of other parties involved in your matter, and the other is advising your clients on how they can or should use their social media. So first, with respect to your use of social media, you'll see there's an example here that a false friending in a personal injury lawsuit led to a new lawsuit against the carrier, the defense firm, and the investigator. And again, this goes towards contacting represented persons and even contacting unrepresented persons through social networking websites. The Pennsylvania Bar Association put out a formal opinion in 2014 on attorneys' ethical obligations in using social media. And after a thorough review of the rules of professional conduct and relevant case law, the opinion concludes that although attorneys may contact an unrepresented person through social networking websites, they cannot use a pretextual basis for viewing otherwise private information on social networking websites. So in other words, you can't create a fake profile and then friend an unrepresented party in order to gain access to information which would otherwise be private. And that's true for unrepresented parties, and certainly you cannot do that for a represented party with whom you are not permitted to contact at all. We can jump ahead to the next slide. Can you advise your client to clean up her Facebook page? And the answer is kind of a yes, but. Yes, you can and should advise your clients on what they can or should post on their social media, and you can and should advise your clients that they should make their social media profiles private. What you cannot do is advise your clients to delete prior posts, which might be relevant evidence in the case in which you represent those clients.
With respect to that, it's worth noting that this is similar to, again, what we had to deal with before the online world existed. And that is, you can't instruct somebody to destroy evidence. It is exactly the same as if you advised a company to shred those documents that show that they are liable for the claims against them. That is obviously looked upon very poorly by every court that has ever seen it.
Exactly. And by way of example, this Allied Concrete case at the end of the prior slide talks about a matter in which a party received a discovery request seeking information from the party's social media profiles. I think it was a Facebook account. The next day, his attorney instructed him to clean up his Facebook page because there was stuff on it that they didn't want to get out. And the client subsequently deleted the Facebook page. In reality, the client had not deleted the page, but had only deactivated it, so the information was still available. And ultimately, following motion practice, all of the information was required to be and was produced. But that didn't stop a sanction against the attorney and the client in the amount of several hundred thousands of dollars to cover the costs that the opposing party's attorney and party incurred in obtaining that information, which had been improperly deleted. So there are obviously risks with respect to compliance with your ethical obligations. You also run the risk of sanctions being entered against you and your client if you are advising your client to delete relevant evidence. And again, I think this and the next slide go hand in hand, and they discuss what you can and cannot post or share on social media regarding pending matters. Pursuant to Rule 3.6, an attorney cannot make public statements that have the risk of materially prejudicing a pending proceeding. And so attorneys should be very careful about what they post, if anything, regarding current matters that the attorney is handling. We'll get into later some additional rules that would apply here, including, again, Rule 1.6 on your ability to share client confidential information. But as you'll see in the next slide regarding posting about judges and trial, a Louisiana attorney was disbarred after making numerous postings regarding judges which were littered with misrepresentations and outright false statements. And later we'll talk about a case in Georgia where a judge vacated a verdict due to the plaintiff's counsel's posts during the pendency of the trial. Okay, and this is just sort of a list again of the model rules of professional conduct that might apply to our use of social media, and I would add to this list the two rules that we've discussed already, Rule 1.1 competence and Rule 1.6 confidentiality. So first up is Rule 1.3 diligence, which states that a lawyer shall act with reasonable diligence and promptness in representing a client. This, in connection with Rule 1.1 competence, requires an attorney to understand how technology, including social media, can impact the representation and to properly use it. A good example is in a personal injury case. Plaintiff's counsel needs to understand the risks associated with his client's use of social media and, again, should be advising the client to make profiles private, not to make new posts that are potentially detrimental to the client's case, but likewise not to delete any potential evidence. And on the defense side, the defense attorney needs to understand that there might be relevant evidence on the plaintiff's social media and must obtain that information in an ethical manner to the extent it's not private in order to be able to use it in defense of the client.
I would suggest that even if it is private, there should still be probably requests for all social media posts in any personal injury case, and that's often true in defamation cases as well. And if it isn't voluntarily given, one should seek the court intervention and or a subpoena to the social media companies if you are aware that there is a social media presence.
Absolutely. Okay, and next up is Rule 1.4, communication. And without reading the rule to you, I think we all understand that a lawyer is required to promptly inform the client of any pertinent developments, consult with the client regarding any major decisions in connection with the case, keep the client reasonably informed, and explain a matter to the client to the extent reasonably necessary to permit the client to make informed decisions. You know, as the practice tip says, attorneys have to be more careful than the average person when posting anything online. I think in connection with the communication with your client, we also have to consider Rule 1.6, which pertains to the confidentiality of information. Rule 1.6a provides that a lawyer shall not reveal information relating to representation of a client unless the client gives informed consent. It's important to understand the difference between this Rule 1.6 requirement and the attorney-client privilege. This rule is not limited to preventing you from sharing privileged information. It prevents you from sharing information relating to the representation unless your client has given informed consent. So to the extent that you want to post about, a good result or a pending proceeding, your client needs to provide consent to you sharing, that client information. Rule 1.6. Go ahead, Josh.
I'm sorry. I just wanted to dwell very briefly on Rule 1.4 outside of the context of social media. I have often described Rule 1.4 as my favorite rule of professional conduct, and I think everyone should have one. But Rule 1.4 is so useful because it requires the lawyer to explain the matter to the extent necessary to permit the client to make informed decisions regarding the representation. And if the client is making informed decisions about representation, that makes it much harder for them to sue their attorney after a case ends badly. That is why communication of what's going on with a case is always vitally important in order to avoid malpractice in general, not just within the context of the use of social media. And I'm sorry to have interrupted you, Alicia.
No, I think that's a really good point, and I think we can, is absolutely correct that communication is arguably the most important part of representing a client. And I think we can tie that back to some of the tips we're giving on social media in that it is important to explain to your clients and to make sure that your clients understand the role of social media in the representation. If you are, in particular, if you are advising your client on how to handle their social media profiles and posts, that advice should be accompanied with, this is why. These are the potential problems if you're posting, as Josh said, that you're out dancing when you're supposed to be, unable to move based on the claims that you're bringing. So, it's critical to make sure that your clients understand the same things that you're obligated to understand with respect to social media usage and the way it impacts their case. Okay. And then just jumping to Rule 1.6, the one other thing that I wanted to really highlight with respect to your obligations not to reveal client information is that duty continues after the representation ends. So even once the representation has concluded, if you do not have your client's consent to share details about the representation, you cannot do that on social media or otherwise. And just by way of example, the D.C. Court of Appeals, I think this was last year, suspended an attorney for posting on Twitter portions of a sealed settlement agreement, a photo of an attorney involved in the case, and comments regarding the attorney's failure to pay the settlement amount, and tagged news agencies and the attorney so that the post was tied with that specific attorney. It was public. It included confidential information from a settlement agreement, and the D.C. Court of Appeals suspended the attorney for that conduct. Rule 1.7 and 1.8 conflicts of interest. With respect to social media posts, I think sort of the takeaway on these rules is that it's possible to, by using social media, to sort of back yourself into a conflict that would otherwise not exist. So to the extent that you're posting, opinions about a matter that would then potentially conflict you out of handling it, or having communications with unrepresented parties that then can conflict you out of representing someone involved in the case, it's important to be cognizant that your social media posts could create a conflict down the line, and you need to be considering those possible conflicts when representing clients. And Josh, if you have anything to add at any point, feel free to jump in. Okay.
Sure. I think the most important thing here is that frequently on social media, you may not know exactly who it is that you are talking to. And it generally behooves attorneys to keep any information about current cases or cases that are maybe upcoming strictly off of their social media feeds. And that goes right to the idea of creation of conflicts of interest if you are dealing in social media with people who you may not understand who they are. It's an area that is a little bit fuzzy and something to be very, very careful to handle.
And just, I don't think we said this, it's on the slide, but I think it's worth commenting. When using social media to communicate, it's important to avoid providing one-on-one advice or soliciting additional information from an individual whom you don't represent. One of the, an area of risk in connection with malpractice claims and disciplinary matters is the client who thinks they're a client and you didn't know they're a client. So to the extent that you get into the area of providing, one-on-one legal advice or advice on a specific situation, you run the risk of creating an attorney-client relationship where you didn't intend to, and maybe you don't realize that you've done that. So, it's really, in addition to keeping your social media activity on pending matters to a minimum, it's important to not sort of, offer advice or opinions on matters that you're not really involved in at the risk of finding yourself in a client relationship that you did not want to be in. And
I'm sorry, Alicia. One of the things that some commentators have addressed is, whether the use of generalized disclaimer language on a social media platform can isolate you or keep you out of trouble on this. And you want to be very careful to make sure that if you are providing anything that even begins to look like advice on social media, that disclaimers that you're not actually providing legal advice for the use of a client is not buried and is prominent and predominates the conversation. I would generally advise to just stay away from it, but if you do get into that, that is something to be very, very careful about.
Okay, next, duties to former clients, and we did cover this a little bit with respect to understanding that your duty of confidentiality extends beyond the conclusion of the attorney-client relationship. Rule 1.9 prohibits a lawyer who has formally represented a client in a matter from certain conduct, including representing another person in a substantially related matter in which the interests are materially adverse. Obviously, you cannot use information that you have learned from a former client against that former client in the future, and you cannot disclose confidential client information regardless of whether the attorney-client relationship has concluded or not. This may come up a little bit less frequently on social media, other than to the extent that you may post about a prior matter. As we've discussed a couple of times, it's important to ensure that you have client consent before you're sharing any information, whether it's a current or former client.
One of the rules that actually does pop up with respect to this that I don't think we have on our list is Rule 5.5, dealing with unauthorized practice. And one of the things that you want to be very careful about is that if you are on social media, you can be giving advice to clients, potential clients, or other folks who are not in a jurisdiction in which you are licensed. And so you want to be very, very careful that any posts you make do not violate Rule 5.5. And I'm sort of throwing that in here because that falls within the communication and duties to clients.
Absolutely, and I think that point segues nicely into the next slide on duties to prospective clients, where the practice tip is one that Josh has already shared with you appropriately, that any posts or blog posts or social media posts that you may make which could even remotely sound like legal advice needs to include a disclaimer that it is not legal advice. The practice tip says a better practice is to require an online acceptance of certain conditions, including that there is no legal advice provided and that no attorney-client relationship is formed. And we see this a lot on, law firm websites. If you go to the website, something pops up immediately that says, by reading anything on this website or contacting us, you're not forming an attorney-client relationship. And that, communicates to these prospective clients or unrelated third parties that you're not providing legal advice to them by sharing information, and can help you defend against the claim that you had in fact created an attorney-client relationship. Okay, Rule 3.4, fairness to opposing party and counsel. And in connection with Rule 3.4, I wanted to also talk about Rule 4.1, which I think is not in our list. Rule 3.4 requires an attorney not to unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material. And this would come into play in the examples we had already talked about, where an attorney is providing advice to his own client as to what to do with their own social media account. And as we discussed, you certainly cannot advise your client to delete or permanently get rid of any posts that might be relevant evidence in your case. But in addition to or sort of related to fairness to opposing party and counsel is Rule 4.1, which covers truthfulness to third parties. And under Rule 4.1, in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. And this includes on social media posts. So an attorney, that example we had talked about previously with the cat food, this is one of the rules that attorney has been found to have violated because the social media posts made by the attorney included knowingly false information that was unsupported by the evidence in the case.
That's also an area where the concept of creating false accounts and trying to friend the other side using false pretenses often comes into play.
Exactly. And as Josh pointed out before, there are ways that are ethically permissible to obtain, another party's social media accounts and posts, and that's through discovery requests or subpoenas. It's not through pretending to be someone that you're not in order to gain access to information to which you are entitled through discovery, but not entitled through deceptive means. Okay, Rule 3.6, trial publicity. Rules, as we talked about before, Rule 3.6 prohibits lawyers from making public statements that will have a substantial likelihood of materially prejudicing a pending proceeding. And I alluded to this before, but in Georgia, recently a judge vacated a $1.5 million verdict in a personal injury trial and ordered a new trial where plaintiff's counsel had posted on social media posts which included comments including detailed specificity about the case, and the court found that those posts had potentially tainted the jury. And so the verdict was vacated and an entire new trial was ordered based on the plaintiff's counsel's posting of details about the case on social media.
This is also an area where you want to be careful in the realm of defamation. As we all know, statements that we make in court are entitled to an absolute privilege under the judicial privilege. But there are restrictions on that privilege depending on what jurisdiction you're in. Some are greater and some are lesser. But one of the common restrictions on that privilege is if you create publicity that is outside of the trial for a comment that was made inside of the trial. That is, in Pennsylvania, we have a well-known case where a complaint was provided to a newspaper in order to be published. Obviously, that's something that the newspaper could have gotten itself, but because the attorney provided it, they ended up losing their judicial privilege. That is something that potentially you could lose judicial privilege if you are providing TikToks or tweets about an ongoing case.
Okay. Rule 4.3, dealing with unrepresented persons. Rule 4.3 states that a lawyer shall not state or imply that the lawyer is disinterested when dealing with a person who is not represented by counsel. And this goes to that example we talked about before of making a fake profile and then friending an unrepresented party in order to gain access to information under false pretenses. Social media is a great resource for investigating parties and witnesses. However, it's important to understand our obligations with respect to ethical use of social media and not to sort of go around those obligations in obtaining the information. And the practice tip provided is that a lawyer can access only what is available publicly and cannot use subterfuge to gain access even with unrepresented parties. Okay, Rule 5.1, responsibilities of partners and managers. And this is the same responsibility that supervising attorneys have over every aspect of their practice and the conduct of their staff and subordinate attorneys. And it is critical for supervising attorneys and for firms to put in place policies and to provide training to their subordinates on how to ethically use social media and on our obligations with respect to that use. If, for example, a paralegal or an assistant creates a fake profile and obtains private social media information from an opposing party, ultimately the supervising attorney is going to be responsible for that improper conduct. So in addition to understanding, your own obligations and following the rules of professional conduct yourself, it's imperative to train subordinates and staff on those same issues so that everyone is following the proper processes to obtain the information that you are seeking.
There's a little note in here. Oh, I'm sorry.
No, go ahead.
There's a little note in here about friending judges, and this is a topic that is interesting in that there is a little bit of a divide between different states with respect to whether you can friend a judge or whether a judge can use social media. There are several states that have said that it is fine for a judge to utilize social media as long as they comply with their Code of Judicial Conduct, and attorneys, of course, have to do the same. But some states, including California and Florida, have adopted a more restrictive view in which they suggest that friending a judge or a judge friending a lawyer can create an impression of undue influence. I think certainly the golden rule would be to stay away from having social media contacts with any judge that you are likely to appear in front of.
Certainly a good point.
Yes, I just, a question popped up that about an existing friend who becomes a judge in Texas, do you have to unfriend? I would say that I have the same issue. There's a judge in my jurisdiction who was one of my good friends from law school, but they are in family court. I do not appear in family court. I'm not really concerned about that. I think the rule really is to stay away from being friends with anybody that you are ever likely to appear in front of.
I think that makes sense. One thing I wanted to add on the responsibility of supervising attorneys, we talked about the responsibility to ensure that your staff and subordinates are using proper methods to conduct social media discovery, but it's equally important to train and have policies in place on how your subordinates are using their own social media and not posting, anything that you couldn't post, regarding pending matters, existing clients, confidential information pertaining to former clients. There should be very clear policies in place as to, how employees and subordinates can use social media, and a good rule of thumb is that no one can post about, existing pending matters and existing clients. Okay, Rule 7.1, communications concerning a lawyer's services. Again, an ongoing theme of this presentation is that our obligations don't change because social media is in place, but it's important to understand how they apply to social media. And just like you couldn't have an advertisement on your website that falsely communicates about the types of services that you provide or your areas of expertise, likewise, your social media posts regarding your practice must be truthful and in compliance with the rules. The practice tips raises a good point where it says, police what others say about you. You may be required to take action to remove or correct the statements made by others. An example that I could think of is LinkedIn has the endorsement section, and you could have someone else endorse you for, a skill or an area of expertise that you don't have. And, you could, if that's your professional LinkedIn profile, you could have an obligation to take that post down or amend it so that it accurately reflects the services that you provide as an attorney, and it does not mislead the public as to your services.
At the same time, one of the danger areas when policing what others say about you is responding to client comments on social media. One of the areas where attorneys have gotten in trouble repeatedly in many different jurisdictions is in responding to things like Yahoo reviews. I guess that's a little stale now, but client reviews about their services and stating information about the clients in response to a bad review. That's obviously a violation, again, of Rule 1.6, and in those areas, you can ask the service to take down the review, but you want to be extraordinarily careful about any response to the review.
Great tip. Okay, next is advertising, which I think we largely just covered in connection with communications concerning a lawyer's services. But again, be aware of the advertising rules applicable to your jurisdiction because they do differ by jurisdiction. And because social media is a newer area, it's certainly a developing area of the law and rules. And so it is, critical to understand what rules apply to your practice in your jurisdiction. One practical tip, if you are going to post about prior results or outcomes, it's always important to include a disclaimer that those results are specific to that matter and those facts, and does not guarantee any outcome in any different or future matter. Okay, direct contact with prospective clients. Rule 7.3 requires that communications soliciting employment from people known to be in need of legal services is explicitly labeled as advertising material. We should be very careful about using social media to directly contact prospective clients who may need an attorney. As a practical tip, you'll see it says avoid solicitation. It's okay to talk to people about the law, but not to single out a specific person or company in an attempt to engage them as a client. And this practice tip applies generally and in connection with social media usage. And as we've talked about, a couple of times, you should establish practices that avoid one-on-one contact on a specific legal issue with an individual who is not your client. Okay, communications of fields of practice and specialization. Again, this is the same thing. An attorney has to follow the rules of professional conduct with respect to social media. It is, in some respects, a less formal platform, but an attorney still cannot claim a specialty, unless the lawyer has obtained a certification or it falls under one of the categories that is permissible under the rules of professional conduct. We talked about the example of LinkedIn making it easy for an attorney to violate this rule. So it's just important to make sure that you are cognizant of what you have put in your LinkedIn profile or your social media profile, but also monitoring what others are saying about you. And as practice tip says, screen all recommendations, or better yet, don't allow them. Make sure you're monitoring, your own online footprint and advising your other lawyers in your firm to do the same. Good idea not to use the listing of specialties on LinkedIn, although those types of specialties are available. Just being cognizant of your obligations with respect to Rule 7.4 and communications that could come across as violating that rule on LinkedIn or other social media.
As has always been the case, and again, it's something that is not unique to social media, unless you have a particular certification, you want to avoid words like specialize, expertise, or anything that presents an idea that you have anything other than great experience in an area. Try and build up your experience, talk about your experience, but stay away from expertise and specialization.
And then Rule 7.5, the same rules applicable to using your firm name and letterhead apply on social media. And so you cannot use a false or misleading name on social media, or misleadingly identify where you are admitted to practice law on social media, same as on your website or in any other forum.
Just note that there was a question about whether a lawyer can comment on negative posts by a client on social media, directing the social media audience to publicly available court dockets and judicial opinions. The answer to that is no, you cannot. That is in violation of Rule 1.6. The Rule 1.6 is extraordinarily general, and again, you want to avoid posting anything about an ongoing client case if you can at all avoid it. I
think that, and we said this before, but it's just really important to understand how much farther Rule 1.6 goes than just protecting privileged information, or privileged communications. And so it's really a best practice not to share, any client information on social media, even if it's otherwise publicly available, without your client's consent. Okay, and then we're just going to round out with some tips for steering clear of some of these social media danger zones we've talked about today, and then we'll try to leave a minute or two to answer a couple of questions. We've said this over and over again. It's important to treat social media as the same as every other form of communication with respect to your ethical obligations. It is easy in that less formal platform to forget or inadvertently fail to comply with some of our ethical obligations, particularly if you get involved in commenting on posts or a one-to-one communication via a public post. So it is really a best practice to avoid situations like that, and certainly to be cognizant of, the risks associated with those less formal communications, which could potentially share confidential information you didn't intend to share, or otherwise violate, your obligations under the rules of professional conduct.
I think even without respect to the rules of professional conduct and ethical constraints, it is a golden rule to never put anything online that you don't want to see as an exhibit at trial. And that goes with all electronic communications, with emails, with texts. If it's not something you don't want someone to eventually put on as an exhibit in a legal malpractice case, don't do it. There was a case many years ago out of Colorado where a lawyer asked some of the other attorneys in his firm what the value of a small car accident case was. One of the partners responded that it probably wasn't worth much because the client was a, quote, toothless cootie, unquote. That became an exhibit on a legal malpractice case that ended up in a multi-million-dollar verdict against the law firm.
You'll see the third tip here is consider everything that you put into electronic format as being forever available for scrutiny. And that is certainly true with emails, with text messages, with social media posts. As it's easy for Josh and I to say because this is what we do for a living, we defend malpractice matters, but it is really important to always have in the back of your mind, anything I put in writing could potentially come out later in a way that I did not want it to come out. And so taking that extra minute to consider, how appropriate the communication is in light of that risk is really important as a malpractice avoidance and disciplinary matter avoidance practice. And one thing that's, I think important to highlight as well, a lot of the examples that we provided today and the tips that we're giving may give rise to some concern or fear about using social media and sort of a tendency to think, okay, if there's too many risks, I'm just not going to do it. And that's not really the answer either. As the fourth tip says, don't just stick your head in the sand. You are required under Rule 1.1 in order to practice competently to understand technology, including social media, and to use it when appropriate for your practice and to your client's benefits. So, we can't just walk away from this presentation and say, never mind, it's too risky, I'm not doing it. You really do have to learn how to use social media in an ethical and effective way in order to provide your clients with competent representation. Any other tips that you want to highlight, Josh?
No, I think that really the biggest takeaway of all of this is that you want to be careful to handle social media just as you would have handled cases before social media existed. And that is, you want to keep your client's information confidential, you want to not disparage other persons, and you want to be very careful about what other people are going to see. And with that, I think we should see if there's any questions in this last minute and a half we have.
Agreed.
Thank you so much, Alicia and Josh. Really great tips and practical guidance for our listeners. The first one, as an attorney, how do I continue to investigate when a witness blocks me Is a stealth account ever permissible?
Alicia,
Okay,
do you want to start with that? I think we've already addressed it, but...
Yes, so we did address that a stealth account is never permissible. The appropriate way to investigate the witness would be to, I assume, because we're saying witness and not an opposing party, that this is a third party, but you can subpoena a third party, and so that would be, I think, the only really option, other than if you can find other publicly available information that you don't need to be, not blocked to obtain regarding the witness. But no, you cannot create a stealth account to investigate, a party or a witness involved in a matter.
If it's the other side, you of course can utilize the normal routes of discovery, and often it's very useful to get a court involved if you're trying to subpoena documentation from social media companies that can be a little bit hesitant to provide information on.
Okay, great. Thank you. Next question. Do I have to do a social media search on new clients and parties?
Have to is probably not the language I would use, but should you? It's not a bad idea. Just like I have a tendency to look up all of my clients and whatever disciplinary actions they may have had, what other legal malpractice cases they may have had, what their firm history is, what their LinkedIn looks like before I talk to them the first time. It doesn't hurt to look at one of your potential clients' social media before they come into you. It's worthwhile noting if the person has a website that has an awful lot of conspiracy theories and untenable positions, you might have a difficult client coming up.
Yeah, that's a good point. And we'll take one more question. I am in New Jersey. I have a YouTube channel. Often people from other states call me for questions. Can I answer with generic laws?
That goes back to the question that we talked about before with respect to being very cautious about inadvertently creating attorney-client relationships and the potential for an unauthorized practice of law violation. There are certain provisions that allow for generalized communications regarding the law, but you want to be very, very careful that you are following Rule 5.5 or the similar state ethics rules with respect to providing advice. And one of the really difficult things with Rule 5.5, and I think it would be even more difficult in the context of a social media, is that the Rule 5.5 or its equivalent matters for the jurisdiction to which you are giving the information. So if you are in New Jersey and you're giving information to somebody in California, it's the California rules of professional conduct that are more likely than not to deal with whether you are actually in the unauthorized practice of law. So that's an area that can be very tricky.
And I think to the extent that you are going to provide any, I think the question said generic advice, it's really important to, include with whatever information you're providing the disclaimer that you practice in, I think the state was New Jersey, you don't practice in that state, and you're, providing advice for that individual to look into an area of the law as it pertains to their state. So maybe you can highlight, what you think an issue might be, but really, really make it clear that you don't practice in that state and, that person should speak with an attorney in their state. You are not representing them. You're just sort of, providing very generic overall, answer to their question type thing.
Perhaps with a banner at the bottom of the YouTube page saying, this is not legal advice for the use of any client or potential client.
Exactly.
Would be a good thing.
Yep, agreed.
All right, very good. At this point, we are out of time for further questions. That concludes today's event. On behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. I would also like to thank our speakers, Alicia and Josh. Thank you so much. Have a great day.